I'll call this meeting to order. Everybody, welcome. I'll do the Pledge of Allegiance today. I haven't done it in a while. Please stand for the pledge. Ready? Begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Do we have any adjustments to the agenda?
We have one, we put election of officers on the agenda twice, so if you'll just remove it from 9A and just complete that task at the beginning of the meeting.
All right. With that change, where did we put it? 8A?
Yes, 8A.
Okay, thank you. Consideration and approval of the minutes. We have the minutes. Any proposed changes? Hearing none, is there a motion to approve the minutes as submitted?
Motion to approve.
Is there a second?
I'll second.
There's been a motion and a second. All those in favor signify by saying aye. Aye. Adopted unanimously.
We also need a motion to adopt the agenda. A motion to adopt the agenda.
Do we need to actually formally adopt the agenda? I don't know
Yes.
if
Yes.
I've ever done that before.
You do, with the adjustment.
All right, is there a motion to adopt the agenda?
I'm sorry, I missed the adjustment. What was that?
Taking it off of
As of
9,
amended.
and they had it in 2 spots.
Oh,
so
I
just moving it to
I motion to adopt the adjusted.
I second it.
Is there a motion and a second? All those in favor signify by saying aye.
Aye.
Aye. Motion adopted unanimously. There is no old business. The first new business is election of officers. I have to tell you, I think it's a good idea to rotate the chairs. Having said that, what is the board's wishes?
I agree with that motion.
No,
But in all honesty, to promote the fairness throughout the board and all that, a rotation of it.
actually, I think it's better to rotate the chairs. There's just a slight learning curve, and I think it's a good idea. Is there anybody who'd be willing to be chair?
Well, as Iredell County rep, I can't be, so
Oh, that's right.
that would be up to you for 3.
I'm the alternate.
Well, board members, I'll do it again if really nobody is willing to step forward.
I think you're the best qualified, the most experienced in legal matters, and being a quasi-judicial position, I think you're the best qualified member.
All right. Is there, can we do this all in one, both the chair and the vice chair? Well, let's take it in 2 steps. Is there a motion to,
Entertain a nomination.
entertain nomination for the chair?
I motion to nominate Jim.
Is there a second?
I'll second it.
Oh, are there any other nominations?
Everybody just took a big step back.
Well, let's see if I can prolong it even more. Is there a motion to close the nominations?
I
Motion to
close
close.
it.
All right. All those in favor of retaining me as chair signify by saying aye.
Aye.
Aye. Passed unanimously. How about the vice chair? Are you willing to do it again?
I believe I'm currently the vice chair,
Yes.
so.
Would anyone like
Unless
to be the
someone
vice
else would
chair?
like to do it. No.
I'm good with the status quo.
All right. I nominate we stay with our current vice chair.
Okay.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
Okay. It's unanimously adopted that we're staying with the chairs as they exist today.
Congratulations.
Yes. That brings us to 8B, consideration of a special use permit, number SP 2023-01. Who's going to be? This is a public hearing. Anybody who wishes to speak, we will swear you in at that time.
Good afternoon. I'm Krista Jordan, planner with Planning Community Development Department, here to
And-
present this item.
And let me look up, because I wasn't prepared, our oath.
You want me to?
Again, please state your name for the record, then raise your right hand and place your left hand on the Bible.
Krista Jordan.
Do you solemnly swear that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Please proceed.
Thank you. This item is SUP 2023-01, the first special use permit we're hearing this year. The property owner is Town of Mooresville. This is the wastewater treatment plant site. It's 244 acres, more or less, located at 369 Johnson Dairy Road. The applicant is Iredell County. The request is a special use permit to allow a telecommunication tower for 911 services at this location. It's in the RLS district. As you can see on the map there, it's in beige. That's the RLS color. It's right on the edge of town. So all of the white you see is Iredell County. The red line you see to the south is the southern planning boundary, and the circles are our nodes from our One Mooresville plan. A special use permit is required to allow this use in this district. So just in summary or in overview, a special use permit is for special use is for a use that is typically considered to be compatible with surrounding uses, but just may need or benefit from board consideration. Existing conditions on site. The picture to the left shows the entrance to the wastewater treatment plant. It's rural character surrounding this site. There's homes adjacent, but not immediately adjacent, particularly driving down the road. The aerial on the right, you can see clustered sort of to the south of that yellow polygon. That's the wastewater treatment plant. It consists of building and multiple large tanks. The area where they're proposing to put the tower is in the upper right of that polygon, outlined in yellow. Sort of that orangey area is nearby. It's sort of the approximate location. They want to center the tower in that square-shaped area up there. This is the plan submitted with the request and it's all kind of gray and white and black, so I'll walk you through it. The left-hand side is a sort of grayed out aerial image, and again, it shows the clustering of the wastewater treatment plant facilities sort of to the south along Johnson Dairy Road. It's not really visible from the road, but it's to the south of that property. And the circle to the upper right of that gray square is the location of the tower, proposed location of the tower. The tower is going to be no more than 355 feet. The reasoning behind the request is to provide greater coverage for 911 emergency services. On the left-hand side of the image on the left shows you current coverage. The white are the gaps in the service. And again, this is sort of to the south of the county. So near that line to the south down there, and you can see the white speckles on the left-hand picture. On the right-hand picture, you can see that it's covered in more, and they've shown the proposed location of the new tower. So for this, because it's for emergency services, it's a somewhat simplified review. We only need to consider the 4 findings of fact. The first of which is, will the proposal materially endanger the public health or safety? The applicant has had this reviewed by the FAA, and they have no problems with the height of the tower. The FCC has no problem with or no concerns with the low-powered equipment to be mounted on the tower, and staff believes that the application meets this standard. The second finding of fact we consider is, will the proposal comply with all relevant town laws and ordinances, state and federal laws and regulations, and any conditions imposed by the town board and agreed to by the applicant? So like I said, the emergency tower is exempt from the considerations of the UDO. So our normal plan review, this will come through as a commercial permit. It'll be a lighter, easier review. There's no subdivision required or proposed or anything. Staff believes that the application meets this standard. The third item that we consider is, will the proposal substantially injure the value of adjoining property, or is it a public necessity? We feel that the tower is a public necessity to serve emergency services, to provide better 911 coverage, and we believe that the application meets this standard. In the application, beyond what's listed here and in the report, you can read that the tower is being located more than 800 feet from adjacent residences. They're considering everything from fall zone for the tower to trying to protect the neighborhood character and property values. Findings of fact, will the proposal be in harmony with the areas in which it's located and be in general conformity with the comprehensive plan? As you can see, all of the orange on the screen is neighborhood residential. Neighborhood residential recognizes institutional uses such as this as a secondary use. So it is supported by the One Mooresville plan. Currently, the site is home to an institutional use, the wastewater treatment plant. And staff believes this application meets this standard. So because we believe that the proposal meets all 4 findings of fact, we recommend approval of this application. The applicant is here to answer any questions as well.
I have one question. The FAA letter lists 2 conditions. Am I correct in saying both those conditions will be included if this special use permit is granted? Specifically, it says, as a condition to this determination of the structures to be marked lighted in accordance with FAA advisory circular, blah, blah, blah.
Yes, you can verify that, if you will, please, with the applicant. And those can be conditions of this body as well.
All right. Thank you very much. Does
Thank
the
you.
applicant wish to speak?
Sure.
Okay.
You're gonna put a light on it. Yes.
Yes, please.
Hi,
Please state your name for the record, then raise your left hand and place your left hand on the Bible.
David Coakley.
Do you solemnly swear that the evidence you shall give to this board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please proceed.
Yeah, so the FAA ruling, the two considerations for lighting and painting, per that standard as listed, we will comply. It'll be lit. It's not required to be painted. If it was to be painted, they would specifically have said, and painted. So it's either or, but it will be lighted accordingly. Yes.
Right. So you have no objection to inclusion of the FAA proposed conditions?
None at all.
All right. Do you have anything else to add to the presentation?
No, I think it's very complete.
Okay, thank you. Is there anyone else who wishes to give testimony or speak on this matter? Are we ready to bring it back to the board then, staff?
Yes, sir, I believe we are. Thank you.
Staff have any further questions on this matter?
Just so I understand what the pictures are, this last one, this Google Earth. I don't know if this is in the presentation itself, but there's a couple different colored pictures. There's a square, a yellow circle and a red circle. So that red circle is out 900 feet, so I take it that's to the closest property.
Yeah, I believe they were trying to demonstrate the closest residence.
Okay.
And some of the exhibits show, I believe it's 877 feet to the nearest resident. And then the smaller circle inside is the fall zone, sort of if the tower were to, worst case scenario,
Right.
fall over, where it would impact.
Okay.
There's a key, if I'm not mistaken.
Yes.
Okay.
All I see is a circle measurement.
Okay.
So that's what I wanted to make sure. The yellow circle is if the tower were to fall, that's kind of the zone that it would fall in.
That's my understanding. If you flip through, there may be another exhibit that has the same symbology with a key. There's a zoom in that I remember looking at a lot. And the applicant is here and can speak to those exhibits.
I mean, I think I'm good. Just wanted to make sure.
Again, and the purpose of this is to improve the emergency services communication system, correct?
That's correct, yes, sir. There may be other utilities mounted on this in the future, but that is the purpose for building a new tower in this location.
Are there any further questions? As I recall, we have to go through these findings one by one and with a voice vote for each. Is that correct? Well, I'm just assuming it is correct. Okay. Is there a motion to adopt the first finding as submitted in the staff report?
I'll motion.
Is there a second?
Second?
There's been a motion and second to adopt the first finding as submitted in the staff report. Can we have a voice vote, please? Roll call vote, excuse me.
Richard Ford,
Yes.
Michael Famularo,
Yes.
James Rupp,
Yes.
Jason Overturf,
Yes.
and Mike Jones.
Yes.
First finding passes. Is there a motion to adopt the second finding as set forth in the staff report?
I so motion.
I'll second.
Been a motion and second. Please have a roll call vote.
Richard Ford,
Yes.
Michael Famularo,
Yes.
James Rupp,
Yes.
Jason Overturf,
Yes.
and Mike Jones.
Yes.
Is there a motion to adopt the third finding as set forth in the staff report?
I'll motion.
Got to have a motion and second. Please, roll call vote, please.
Richard Ford,
Yes.
Michael Famularo,
Yes.
James Rupp,
Yes.
Jason Overturf,
Yes.
and Mike Jones.
Yes.
Finally, is there a motion to adopt the fourth finding as set forth in the staff report?
All motion.
I'll second.
Been a motion and second. Roll call, please.
Richard Ford,
Yes.
Michael Famularo,
Yes.
James Rupp,
Yes.
Jason Overturf,
Yes.
and Mike Jones.
Yes.
The matter is approved. Is there anything further on this that I've forgotten?
The options on the screen say, did you have any other?
We have an antsy person in the audience. Come on and tell us what I've done, Erica.
Thank you. Oh, vote to issue the special use permit.
I motion to issue the special use permit.
I second it.
Who seconded? Okay.
So we're going.
Roll call vote.
We're going with option number one.
Yes.
Yes.
Richard Ford,
Yes.
Michael Famularo,
Yes.
James Rupp,
Yes.
Jason Overturf,
Yes.
and Mike Jones.
Yes.
All right. Before we move on to the second item on the agenda, let's take a 5-minute break so staff can fix my computer. Please come up here and tell me what I'm supposed to do. Hopefully it'll just go back to where we left off. So,
Back row or that button they say,
just hit this one. Let's go back here.
okay, sign in.
Sign in.
And I've got a new post-it note for you.
Ah, excellent.
So this will be your email address. So it's your first initial, last name at mooresvillenc.gov. I'll go over here.
Okay, what am I putting in here?
J-R-U-P at mooresvillenc.gov. And then yeah.
This.
Yes, sir.
Gotcha, got it.
Next, I think it says,
Yeah, I think, aren't we supposed to create one?
no, you should have one already.
Oh, okay.
So the username may be incorrect.
Should it just be JRUP?
Yes, sir.
Okay.
And you just get into the tab on the password. You've got double support.
Pardon me?
You've got double support now. An angel on each shoulder.
Okay.
And the number there is the long one.
Yeah.
Now you can't play it on your town email.
I hadn't thought of that. That was a mistake. All right.
Gotcha, Jim.
Okay, let's go back on the record to the second item. This is Administrative Appeal, AP 2023-01. All right. Do we have a staff report on this?
Mr. Chair and Board, the town would like to actually start this with a motion to dismiss this appeal based on its untimely filing and lack of subject matter jurisdiction. I have some packets I'd like to hand up and give to opposing counsel as well. There is a statutory deadline for filing. There's a statutory deadline for filing an appeal to administrative appeal. That time is 30 days from the date of presumed notification of the determination letter. In this case, the statute gives us an option of how to provide that notice.
Thank you.
It can be by personal delivery, it can be by email, or it can be by first-class mail. In this case, the town chose to provide the letter of determination by email, and then to follow it up with first-class mail as a secondary precaution. The statutes also allow for that presumed date for an email to be the date it was sent. The date of this email was sent June 27th, which means the 30-day period ran on July 27th. The appeal here was not filed until August 1st, which was 5 days after the appeal period had run. This is not a waivable requirement, and when there is an untimely filing, the North Carolina courts are very clear that it is a jurisdictional matter and that there is no subject matter jurisdiction with the board or the court in those cases. I can go through these statutes with you to point those out if you'd like. What you have in front of you is Exhibit A, which is 160D is the chapter of the North Carolina General Statutes that covers local planning and development regulations. Chapter 160D-406, you'll see that I've highlighted subsection D, where a jurisdictional matter can be brought and be decided by the board chair, and then it can be also appealed to the whole board if necessary. Your Exhibit B is 160D-405. Again, in subsection D, it talks about the 30 days from receipt. Your Exhibit C is 160.
Hold on, I haven't caught up with you yet.
Oh, I'm sorry. I'll slow down. So this is just setting up the standards. 160D403 is your Exhibit C, and it talks about the manner in which a determination letter can be given. You'll see that it can be delivered by personal delivery, email, or first-class mail. Those are all options given to the administrator. And then finally, your Exhibit D is 160D110, which is a general provision of 160D, and it talks about how electronic documentation is a writing, and that it is to be presumed to be sent on the, or received on the date sent. 3 of the remaining exhibits, E, F, and G, are affidavits by Danny Wilson, Ann Burns, and Patricia Ray. The one you need to pay the most attention to is Exhibit E. It's Danny Wilson's affidavit that sets out that he sent this email on June 27th in the morning. And as Exhibit B on that, you will see that there is an email confirmation stating that it was sent on June 27th, 2023 at 8:54:14 a.m. That's highlighted at the top for your convenience. The other affidavits are just in here to set out our normal procedure for first-class mail, which was our secondary means of notification. And then Exhibit H is the application for appeal, and you will see that it was signed on 8/1, again, 5 days after the 30-day period had run. And for those of you who are not familiar with the term subject matter jurisdiction, because that is a legal term, that is simply the authority a board or a court has to hear a matter, and when something is not timely filed, it strips the board of its subject matter jurisdiction. It deprives it of it. It means you can't entertain it or make a decision. You don't have the authority to do it. So given all of these things, and I do have a case, if you need it, that talks about subject matter jurisdiction and untimely filing. If you would like for me to hand that up, I will. But based on all of the foregoing, we would ask that this board dismiss this matter as untimely filed.
Thank you. I'm sorry I jumped the gun. I thought that was just going to be a legal argument, but now we have submission of factual matters as to when things were sent.
Which we object to, of course.
Then we'll have them introduced into the record. But before we do that, can we get to what your argument's going to be so we understand where we're going? Then we'll try to clean up the record.
I would note, first of all, that this is the first we've heard about it. There's affidavits that are attempting to be introduced. I'm not sure the rules are exactly the same in this setting, but certainly if we were in Superior Court, we would be given some additional time to prepare affidavits of our own, contesting their affidavits. And we would certainly request that we be given the opportunity to do that so we can respond appropriately to what's being filed here today. However, looking at Exhibit B, the idea behind service requirements is still always going to be that the person against whom service is being argued has actual notice of what's going on. And under subsection D, time to appeal, the owner or other party has 30 days from receipt of the written notice of the determination within which to file an appeal. He did not receive the notification in question until the 3rd. He filed the appeal on the first day of the following month, which would be within 30 days of actual receipt of the written notice of the determination, which would be timely under the rule here. I would also note that we did not receive as council notification until that time as well. So if there was an email sent out earlier that Mr. Graham didn't receive, it was not sent to us. We didn't receive it as his counsel. And so when the appeal was filed, it was certainly timely based on the time he actually received the notice.
Thank you.
Could I respond?
Let me tell you what's going through my mind, and then y'all can figure it out. Looking at B, it says, in the absence of evidence to the contrary, notice given pursuant to General Statutes 160B-403B by first-class mail is being received on the third business day following deposit of the notice for mailing with the United States Postal Service. I have a feeling that Joshua's Farmers Market wishes to put Mr. Graham, call him for testimony, in which case he may well say he did not receive this until the 3rd. And that would seem to satisfy, unless you have contrary evidence, the phrase, in the absence of evidence to the contrary. Am I missing something in this?
And you're talking about 160D 405?
160,
I think
yes,
that's pretty clear.
160D 405 subpart D.
Yes, that is talking about first-class mail, and I would point you to 110, which is the email, which is presumed on the date sent. And that there are cases here that are legal and obviously legal in nature that talk about constructive or actual notice, and that the purpose of legislation, we have to give legislation a purpose, and the purpose is so that everyone knows when the time period starts and when it ends. And to that end, they have given us presumed dates, which being emailed is the date sent. We have confirmation of when that was sent with the time date stamp. That's very clear. Also, council did not receive any of this because there was no council listed on the application. And finally, we do have a case that we could also get copies of for you about notice being sent by fax to a fax machine. There be a confirmation of that fax machine, because in that case, it was allowed in that nature. The attorney was out of town on vacation, but the court found that it was received on the date the fax machine received it. And that's the way the law reads. This is to have a purpose, and to give it a purpose, you have to say it is presumed on the date sent. And the date sent was June 27th. But even if we said the first class mail, that was mailed on June 27th as well. 3 days after that, the 30-day period would have expired on July 30th. They've still missed the filing date by 2 days, even if you did that. But our argument is that it is the date sent of the email, which was June 27th. So unless there is some contrary evidence to the email being sent on that date, I don't believe they could prevail on this argument.
Thank you. I'm concerned by the following. 160D-403 subpart B refers to determinations and notices of determinations, which is all well and good. 160D-405D specifically refers to the time to appeal. And without knowing a lot about this, it seems that they conflict with one another. So the way I can resolve the conflict is saying that the more specific governs over the more general. And it seems to me the time to appeal is governed by 160D-405. Are there cases that are going to resolve that for me?
She just told you.
The 30 days is the 30 days. The 110 is talking about the email. This is just simply regarding the first class mail. But even if we look at I would go back to your fact about putting Mr. Graham on the stand. The application itself says that he received it on or about July 3rd. There is no specific date that he received it, that he states in his application even. And so if his memory is now better after the fact, several months after the fact, I'm not sure how that would work. But unless we had, again, the whole purpose of the statute is to set a date so that all parties know when that date starts and when that date ends. And under either version, whether it be the email or the first class mail, they have missed that deadline by either 5 days or 2 days. And I can give you multiple cases where the statute has been, the filing has missed it by a day or two, and the court has said, our sympathies are with you, but we cannot change the law. This is not this must be strictly construed, and it is not something that can be varied or waived by the court.
All right, here's what I'm trying to resolve. It says, in the absence of evidence to the contrary, notice given pursuant to General Statute 160D-40B by first class mail is being received. So you're saying that in this case, notice was not given by first class mail, or rather it was given by email, and that should govern.
It was given by email, and it refers to 403 in 160D-405. It puts you back to 403, which says it can be delivered by personal delivery, email, or first class mail. Here we have an email, we have a confirmation that it's valid, and I don't know how you, unless you have evidence to the contrary of that email being sent on that day, I don't know how this you could prevail on that argument.
Who are you prepared to call to verify when the email was delivered?
It's right there. It's in the affidavit.
You need to call them.
I need to call Danny Wilson to verify that what he's already sworn to.
But he's got a sworn affidavit in here.
I took it under oath, but if you would like to call him, we can.
Please do.
Our concern, of course, is you know, we're talking about notice. We're not talking about some sneak attack by the town of Mooresville to try and slide something by my client. You know, they say that we're not listed as counsel. There's no place on the form to list counsel. We have been involved in this from the very beginning, and the town is well aware of the fact that we represent Josh. And so if they're going to sit here and tell the board without prior notice to us today, throw affidavits without prior notice to us, I would simply ask that the board take that into account. And one of two things needs to happen. Either we get put on the next hearing date to give us time to respond to these affidavits, or the people that sign these affidavits need to be here and be subject to cross-examination. I've looked at Mr. Wilson's affidavit, and all he says is he gave it to somebody else to send, and that the person that actually sent it's not here.
Actually, it says he sent the email himself, and that he has the confirmation.
Yeah, I don't
Regardless,
understand.
it wasn't received.
Again, there's a presumed receipt.
But any presumption is going to be rebuttable in this
And I would
situation.
object to there being this
Hold on, counsel.
conversation about
Counsel,
sneak
hold.
attacks.
Please hold. Let me ask a question here. If the board rules today it's jurisdictional, and you fail to meet the jurisdiction, what would stop you from asking Mr. Wilson in writing for the determination again, so it could be filed in a timely fashion?
I don't know that, I would have to research that and see if that's
Let me
a
ask Mr.
possibility.
Mr. Wilson, if they submitted the identical question to you tomorrow afternoon, would you respond to it so that it could be appealed in a timely fashion?
Well, how many appeals did it get?
How many bites at the apple should someone
That's
take?
what I mean, is if we rule today and then he comes back and says it again, I mean,
The
it's
only
already been
thing-
decided.
We're not ruling today except on a jurisdictional matter. Do we have jurisdiction to even hear it?
Danny would need to be sworn in, I think, if you're going to ask him a question.
I think it's clear we don't have
I think it's
jurisdiction.
time to do that.
Okay.
Do we have to vote,
Any
do we have
advice
to,
here?
do we have to rule on the motion? Is that
Well,
kind of where we're at?
we haven't done anything yet.
This is the chair's decision. And then
Sure. Yeah. 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 Okay. If you want to put Mr. Wilson, bring him up. I think that's going to be the start.
So, Mr. Chairman, just to clarify, is Mr. Wilson coming up for you to ask a question that you wanted to ask, or for me to figure out?
Well, we'll start off with me, but then both
Just wanted to
council can
clarify.
go from there. Please state your name for the record, then raise your right hand and place your left hand on the Bible.
Danny
Do you solemnly- Excuse me. Do you solemnly swear that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Mr. Wilson, have you heard the discussion we've had with council about when an email was sent to Mr. Graham?
Yes, sir, I did hear that discussion.
Who sent that email informing him of your determination?
I did.
And when did you send it?
I sent it, as council described, let me make sure I get the correct date here, the morning of June 27th, and I sent it, I will add as well, through our permitting portal, through which Mr. Graham applied, which has the email address for his permitting portal access. So it was sent through that system to the correct email address. It is registered for Mr. Graham, which he has since used for other applications, so the email address was valid.
And you just looked at your affidavit just to refresh your memory as to the exact date, correct?
Yes, sir.
All right. Counsel, do you have any questions?
So, you have your affidavit in front of you?
I do not have the affidavit
I'm gonna-
itself. I have the attachments in front of me.
So, you're testifying that on the morning of June 27th, at approximately 8:54 p.m., you emailed this to Josh Graham at the email address on file.
Yes, that's
This
correct.
application.
Mhm.
And then, what did you do after that? Did you make any other, did you send this in any other means?
Yeah, so I also mailed it first-class mail, or I'm sorry, I had my administrative assistant send it out first-class mail as well to Mr. Graham, to the address listed in the application.
And look at Exhibit B attached to your exhibit. Can you verify the address that you sent that to? The email address?
Yes, email address is josh'sfarmersmarket@yahoo.com.
And is this the confirmation? Did you print this off? Is this the confirmation? Do you recognize it?
Yes, I did print this off, and this is printed straight from our system, showing that it was sent through our permitting portal.
And when you send this through the portal, does it have a subject line, or who does it show it's coming from? The to line of the email? Do you know that? It's not in your affidavit, but.
I'm sorry, what was the question?
So when you send an email from your town account on this IBT, how does it show up in the recipient's mailbox in the to category, or the from category, sorry, the from category? Does it show at Town of Mooresville? Does it show at Danny Wilson?
That I do not recall offhand. It definitely appears, I've done it personally, and also as many different test applications. It definitely is a official Town of Mooresville notice. I do not recall exactly how it
Does show that
reads.
it was from the Town of Mooresville in some capacity?
Yes, ma'am.
Okay. I don't think I have any further questions at this time.
Mr. Wilson, this exhibit be attached to your affidavit. Is the portion starting "Hello Josh Graham" and ending with Project Farmers Market designation the actual email you sent?
Yes, sir, it is.
All right.
as well as the HTTPS at the bottom as part of the email.
All right.
Yes, sir.
Do you have any questions, sir?
I do, just a few. Mr. Wilson, did you send the email to counsel for Mr. Graham?
No, sir, I sent the email to the applicant listed in the permit portal, and the applicant is welcome to add any users deemed necessary for a project. However, none were listed in this, so the applicant was the only one notified. Had there been other users identified in that project application, they would have been notified as well.
Is there a place on the form to list other users?
Yes, sir, there is.
On the form?
So yes, sir, when you fill out your electronic application, there's a place to add any new number of applicants on the applicant side. So you can add architects, engineers, transportation engineers, building construction folks, a whole slew of different people can be added on the applicant side.
Is there a place specifically to add counsel?
I believe there's an other that you can check and then add in anyone else you would like to include. I
So
do
not
not,
specifically for counsel?
not that I recall, no, sir.
Did you request a read receipt on the email?
No, sir, through the system, it does not have a read receipt.
So do you have any evidence whatsoever that Mr. Graham actually received the email?
Other than the fact that it is the email with the registered account, and that account has been used numerous times to apply for permits, and that is the account that is tied to this email, I do not have a read receipt, no, sir.
And again, I want to make sure this response is clear. Any proof whatsoever that Mr. Graham received that email?
There's no proof he received it, no.
Thank you.
Mr. Wilson, did you ever receive an undeliverable notice on this email?
No, I did not.
And this was the email sent, but was there an attachment to this email with your determination letter on it?
There's a hyperlink in it that will lead the applicant back to their project page, which is available to them 24 hours a day, 7 days a week, in which they can see everything, including the determination letter that was attached to the project.
And had Mr. Graham used this portal before for applications and knew that that's the way it was going to be responded? I mean, most people know that you're going to respond via the portal.
Yes, he's familiar with the portal. He has used it before, and he's used it since.
One further question was the application that was submitted by Mr. Graham in this case, was it even filed electronically or was it filed by paper?
The application for the determination was filed electronically. On April, I'm sorry, it was probably pre-April 20th, but you can see in staff report attachment, the farmer's market designation request. This is from the project portal. As you can also see, as the applicant and the contact information, as well as the email address that is attached.
Is there anything further, counsel?
Not from this witness.
All right. Do you wish to put on another witness?
Yes, Mr. Graham needs to be heard on this issue.
All right. You may step down, Mr. Wilson. Please state your name for the record
Joshua Graham.
and raise your right hand and place your left hand on the Bible. Do you solemnly swear that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Counsel, you may proceed.
Real quick, Mr. Graham, you've heard discussion of this email that was purportedly sent to you on, I guess, June 27th.
Yes, sir.
Did you receive that email?
I did not.
When did you receive the letter determination in the mail?
Letter was received, opened July 3rd.
That's all. Thank you.
The city was to, questions to Graham?
Mr. Graham, you stated that you opened the letter on July 3rd, 2023.
Yes, ma'am.
That you could have received it before.
It's possible. I opened my mail. That was a really hectic week, but I got home from work one afternoon, not too late, and opened mail, and there it was. And I know it was July 3rd because I sent screenshots at that time to one of my lawyers.
So you were working that week?
Yes, ma'am. We work 7 days.
Okay, you weren't like out of town?
Oh, no, ma'am.
Okay. And you are the owner and manager, assuming?
Yes, ma'am.
And you are in charge of all the mail that goes in and out?
Yes, ma'am. Yeah, what comes to my home, yes, ma'am.
And you're in charge of the email? The Josh's Farmers Market?
We actually have 3 sets of eyes on the email, but that is my primary email.
And you state in your request for determination, sounds like you guys have a lot of farmers and vendors you have to be in constant communication with, right?
Yes, ma'am.
So do you communicate with these vendors by email?
Mostly text message, to be honest with you.
So how often do you check your email?
Well, I do check it daily, but not for business-related ventures, but I do check it daily.
So you don't check your business email for business
But,
related vendors?
no, we have one main email. Everything comes through that email. But I check it daily for real estate purposes. So that's what I was referring to.
So you check your email daily?
Yes, ma'am, I do.
Who else checks your email?
I have 2 market managers. Franda Ballard and Avery Strickland.
So it's possible that this email went into that email and just nobody opened it.
Well, if that is the case, I was able to scroll back all the way to the 27th, just to make sure that I did not miss something. And there is nothing in my main email or my junk mail, because every once in a while something will get kicked to junk. And I do not have a record of that. I do know that it would not have been erased. I'm not able to check my trash, but I have someone checking that right now.
The trash only typically is aggregates. So somebody, like Ballard or Strickland, somebody who works for you, had deleted it.
Well, they know that if anything market related, if they open it, and I don't, and they're the first one to open, they send me screenshots at that time.
You can't say for sure what happened to you in this case.
Well, I mean, I can, because there again, they know the routine. This is not something that we've done just here recently. But I am curious myself, if there was an email sent, why I do not have a record of it. Because I'm not going to say that I am beyond making a mistake and had overlooked it. I just cannot find it. No, it's got my curiosity up.
Is Josh's Farmers Market, the Josh's Farmers Market at yahoo.com, the same one that you placed onto your IDT portal?
Yes, ma'am. We do everything through the IDT with that email.
You're familiar with the system and how that works?
Yes, ma'am.
And
Any other questions, council?
I want to make sure that I understand your testimony, Mr. Graham. Are you saying that you received the letter on July 3rd?
Yes, sir. That's when I received it and opened it.
That's all, thank you.
I'd like to go back.
So it takes a
Mr.
week
Graham,
to mail a letter
initially you
from
said
Mooresville
you
to-
opened the letter on July 3rd.
Yes, sir.
But just to be clear, you're saying that's when it was received?
Yes, sir. Well, that's when I received, you know, that was 2 months ago. But to my understanding, I got home that afternoon. It was not too terribly late. My wife's good about picking up the mail. She put it on the bar, and I opened all the mail because there again, it wasn't too late. And that was July 3rd. The only reason I know it was July 3rd is that was when I sent the screenshots, and I did that immediately after opening.
Sorry, just for clarification, if I may. So, you said earlier that you could have received the letter, you just didn't open it. Until
Best of my knowledge, that's when I received it and opened it. I mean, that's the best of my knowledge, yes.
But could it have sat on your counter when your, brought it in?
Yeah, she had picked up the mail that day and had left it sitting out, and so in place of moving it, I picked up the stack and opened it, and it was in there. Didn't think anything about it at the time until I saw the date on it. But it's not unusual for Mount Ulla, the mail, to do that. It's just with it being a small post office and mail carrier, we're sort of used to stuff not getting to us in a timely fashion. That's just the nature of it out there.
No other questions?
Council, could we stipulate that the letter was mailed on June 27th, or do we want to wait the 10 minutes to get Ann Burns over here to testify? It's up to you.
If we're going to agree that the letter was sent on the 27th for purposes of the 3-day rule, then I've got a problem with that. If
All right.
if all we're saying is that's
All right.
when it was mailed and we're looking at when it was actually received, no problem.
Obviously, we'll use it for the 3-day rule. So if it's important to you, we'll get her over here.
It's important.
We'll take a recess. Please call Ms. Burns, have her come over here so she can testify. I realize we have a notarized copy in the record already. Okay, Ms. Burns. Bear with me while I try to figure out the oath here. Okay, please state your name for the record.
My name is Ann Burns.
Then raise your right hand and place your left hand on the Bible. Do you solemnly swear that the evidence you shall give to the board in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Could you give the witness exhibit, what is it, F, I believe? Are you looking at the affidavit of Ann Burns?
Yes, sir.
Do you remember the letter that this refers to?
I remember mailing a letter. I don't remember the exact date because, of course, it's this many months past, but I do remember the letter.
Okay,
Yes, sir.
looking at the affidavit, does that refresh your recollection as to what you did with the letter and the date of it?
Yes, sir.
Okay. Did you mail the letter, or did you give it to somebody else in the office to mail?
When letters are given to me, I take them, prepare them, take them upstairs to the mailroom, put proper postage on them, and then I put them in the mail bin to go out to the post office.
All right. Council, have any questions? Okay. As I understand, you may, okay. Oh, I'm sorry. I didn't hear you when I said, does council have any questions?
Probably because I turned this off. Good afternoon, Ms. Burns. Is it your testimony that on June 27th, 2023, there was just one letter that you placed in the mail?
I cannot say that for certain, sir.
Do you specifically recall placing a mailing to either Josh Graham or Josh's Farmers Market in the mail that day?
I remember placing an envelope addressed to Josh in June on that specific day. I cannot say for certain, but I can say that if Mr. Wilson or anybody in the department gave me something to mail, it was mailed that day.
Now, you don't take it to the mail yourself. You just place it in the bin to be taken to the mail, correct?
Correct.
So you don't have any independent knowledge of when the mail was actually taken to the post office?
I do not have firsthand knowledge of that, no, sir.
I think that's all I have. Thank you.
You're welcome.
Okay. You may stand.
Mr. Chairman, if I may just ask one follow-up question.
Sure enough.
Ms. Burns, are you also the person that receives the mail from, or for the planning community development?
Yes.
And did you ever receive a non-deliverable or returned envelope saying undeliverable at any point for Mr. Graham?
No, I never received that. I would have given that to Danny immediately.
No, no questions.
All right. As I understand it, Patricia Ray is not here today. Council, I have in front of me a notarized statement from her that the letter in question was placed in the mail on June 27th. And I think that is sufficient for this hearing.
I would point out that we don't have an affidavit from her that the letter in question was put in the mail. She said she put letters in the mail, not the particular one at issue here.
I understand. Is there anything further on the jurisdictional matter?
Yeah, I still think it's inappropriate for us to be considering a motion to dismiss today with zero notice to my client before we showed up and started the hearing. And you know, that's troubling to me. Obviously, you guys are going to get to make the determination as to whether that's really an issue or not.
What would you request us to do in the alternative? To continue this matter so you can file some legal argument?
Yes. Yeah, so we can do the necessary research. We can try and figure out what happened with this email in a little more detail. I mean, they've done what they can do today. Can't find it anywhere. Certainly didn't come to my office. And I am very interested from just from a practical standpoint, whether there are notice requirements for a motion to dismiss at a hearing. Obviously, there's been discussions prior to the hearing. There were stipulations that we entered into. Not one word said to me about a potential motion to dismiss, about affidavits, about anything else.
That troubles me also, that that wasn't brought up earlier. Sure.
Counsel, is there a particular, excuse me, statute or rule of procedure that you can point to that requires advance notice of a motion like this? I mean, I understand just the general proposition of, hey, we just heard about this now, but right now what we're looking at is 160D 406B, and all it says is objections regarding jurisdictional and evidentiary issues, including but not limited to the timeliness of an appeal or the standing of a party, may be made to the board. And it doesn't say anything further about when or how much in advance that's supposed to be made. So I don't know if there's another. My hunch is the answer is no, or otherwise you would have cited to it. But I'm looking as well, and I can't find it.
Citing to it would suggest that this happens regularly, and that I would know that site off the top of my head, which I don't. But I would like the opportunity to find out.
All right, thank you.
While we usually loosely follow the rules of procedure and evidence here, we are not bound by them, and there is nothing in our rules of procedure that require notice of this type of motion, or any motion. There's really not any procedure that we have for motions, and the statute does not give any. And then I would just remind you that this is a matter of credibility, and we have a emailed notice. The email is supposed to be on the date sent, it's presumed received. We have that confirmation, and then we have testimony from Mr. Graham that it could have sat there and I opened it a few days later, but then asked again, no, I'm sure I received it on that date. I don't think that we have convincing substantial evidence to the contrary that it was received on a different day than the email date sent.
Thank you. I understand.
Might want to take
no, please. I understand. I just want the board to get it right, and I want the board to be fair about it. I have no problem with continuing this matter so that you can file whatever legal precedent you have on this matter. I don't know that there's going to be a lot. So I have no problem with that. I'm throwing this out to the board. And I'm also hoping, if the board does that in the next 30 days you'll find out if you simply can avoid all of this jurisdictional matter by asking for the determination from Mr. Wilson so that you can file it in a timely fashion. That's where I'm inclined to be. I simply want to make sure we get it right. There's a question of law here that I don't think anybody has researched. Where does the board stand on it? If not, I'm going to continue unless the board wishes to do otherwise.
I think the town's made its case that he didn't meet the deadline based on the law.
Okay.
I would agree.
All right. So, let me think about procedures here. Since we're not going to continue it, then I'll make it easy. I'm going to rule that the letter was properly mailed on the 27th. There is no evidence that it wasn't received within 3 days. The only evidence we have is I didn't open it. With that, I think that there is a jurisdictional problem here, and this board does not have the jurisdiction to hear this appeal. Is there a motion to?
It's your decision.
I know. Yeah, I know it's my decision. The board can, I think, overrule me on this. It's the way I'm reading this.
It's appealable to the whole board, but it's your decision personally.
Okay, that's my decision. Does the entire board wish to hear it, or is my decision going to hold?
What's not us to appeal?
Do you wish to appeal it to them?
What's our time frame to do that?
Right now.
Then yes, we appeal to the full board.
All right. board wish to consider this matter and overrule my decision?
I motion to dismiss.
I second the motion to dismiss.
Okay. I'm
Yeah,
sorry what dismissed.
So-
Is the motion to accept my decision or to overrule my decision?
Motion to accept your.
Accept your decision.
All right. Is there any discussion of the matter?
I think it's more narrow than you even said. I think the email was for sure sent on the 27th, and according to this statute, it says that's the day it was received. The 3-day for the physical mail is
Immaterial.
different and almost and immaterial because it was sent by email.
On the 26th, if my memory is correct, just for the record.
No, it was dated the 26th, it was emailed on the 27th.
It's dated the 26th, yeah. Emailed the 27th.
All right, then let me amend my,
Can I be heard before you?
Yeah.
As counsel. I just want to direct the full board's attention to its Exhibit D in the packet the council for the town distributed. It's 160D, 110C. And it applies throughout the chapter. And so under subsection C, if everyone's there, it says, unless specified otherwise in one of the statutory provisions, and in the absence of evidence to the contrary, delivery by first-class mail shall be deemed received on the 3rd business day following deposit of the item for mailing in postal service, comma, and delivery by electronic mail shall be deemed received on the date sent. So in the law, what this creates is what's called a presumption, a rebuttable presumption. And so what this is saying is the rebuttable presumption, if you're going by first-class mail, the rebuttable presumption is that it was delivered within 3 days. That can be rebutted by evidence to the contrary. And then, assuming that phrase, in the absence of evidence to the contrary, applies to the electronic mail portion of this, which I believe it does, at least my construction of it is that it does. Again, if you're giving notice by electronic mail, it is going to be deemed received on that date, but that presumption can be rebutted by evidence to the contrary. And so the question, I think, that in terms of formulating the board's ruling and the basis for it is, if you're basing this determination upon this rebuttable presumption, the question is, was there, as to each of these methods, was there evidence to the contrary that would rebut the presumption? And on that note, I will simply note that with regard to the email issue, there was testimony by Mr. Graham that he did not receive it. Now, whether the board chooses to credit that or not, or I'll just say, but there was testimony from him that he did not receive that email. With regard to evidence as to whether by mail he received it earlier than the 3rd, I'm not one to make the decision, but as I heard it, I think that the testimony was equivocal. I think there was, I think you could, the board could reach differing conclusions based upon what he said. I hope I clarified things instead of making things harder.
Can I ask a question on that? So it says, and delivery by electronic mail shall be deemed received on the date sent. That has nothing, it says nothing about received or verified. The way I interpret that is, as long as they hit the button send and they can present evidence that it was sent on that date, that's what we presume.
Unless, in the absence of evidence to the contrary.
I see.
So the question is, if there was evidence, which there was testimony that, there was testimony that, yes, we sent it on that date, but there's also testimony that, well, I never received it.
Well, receiving is different than sending. There has been no testimony that it was not sent.
True. I think then the question comes, in the statute, when the phrase "in the absence of evidence to the contrary," does that mean evidence to the contrary of?
I would say that there has been no evidence submitted that the email address did not receive this.
Counsel,
There was a-
counsel, please.
Yeah.
We're at the
Yeah.
board at this point, okay?
Yeah. But to your point, the question is, in the absence of evidence to the contrary, is that evidence to the contrary that it was deposited on that day or received? And I think that's a good,
Well,
that's a good question.
The word is sent.
Yeah.
So absence of evidence that it was not sent. And I haven't seen any evidence that it was not sent. And I do see electronic verification that it was sent. on the 27th.
I mean, I would say simply, like, in my reading of the familiarity with statutes like this, is that the purpose of this is to create a presumption of receipt based upon the evidence of when it was sent, and it is rebuttable, and it's rebuttable typically not by evidence to the contrary of when it was actually sent, but when it was actually received, in my experience. But
That's
that's
the way
good,
I'm reading
yeah.
the statute also. So that's why I'm saying that I don't think we had any strong evidence that it wasn't received. All we had was it wasn't opened. And then we had some other testimony of how it gets to the house, sort of thing. But that's, so my ruling, which has been appealed to the board, is that it was mailed on the 27th, it was received within that 3-day period, and the appeal was not filed in a timely fashion. And that has been appealed. There is a motion and a second to accept that ruling. Is there any further discussion? We have a roll call vote, please.
Richard Court,
I agree with the chair's decision.
Michael Fenularo,
Agree.
James Rupp,
Aye.
Jason Overture,
Agreed.
Mike Jones.
Yes.
Okay. Is there any further matter to come before the board?
Do we need to draft a report for this, for dismissal, or is just, we're glad to, but
Please do.
I'm sure.
Yes.
Yeah, please.
If you'll do that, typical, same procedure we'd follow in Superior Court, just put it together and circulate it first to opposing counsel and then submit it to me. Close the hearing, close the evidentiary.
Yeah. This evidentiary hearing is closed, and you will, somebody's going to submit the order, I just heard, correct? Okay. Is there anything further to come before the board? Having heard none, is there a motion to adjourn to our next regular meeting?
Motion to adjourn.
Second.
All in favor, signify by saying aye.
Aye.
Aye.